We're now joined by legal expert Reitumetsi Benedict Phiri. Thank you so much for joining us. Always good to talk to you.
Thank you, Kira, and good evening to the viewers.
All right, what are your thoughts on the judge's recusal from this trial? Most people are saying that this really goes to protecting the integrity of the process, even if he admits that he hasn't done anything wrong in particular.
Absolutely. I think this is a good case of judicial leadership on the part of people. I think he exercised foresight, given his experience of the matter and the manner in which it has been litigated by the parties. I think he foresaw that if he continues making rulings which involve pronouncement from the facts of some of the matters which were common in some of the applications which have, dogged the matter before it actually starts, the trial starts in earnest. I think he foresaw that he might end up in a position where the trial ends with a question mark over whether he actually did afford Mr. Zuma a fair trial and whether there will be a reasonable apprehension that he would have been biased given those rulings that he made. So I think this was good judicial leadership on his part. He applied the law exactly how it should be applied insofar as recusals are concerned, and I think it will preserve the integrity of the trial going forward. And certainly the question of his recusal or bias won't become a matter that plays into whether Mr. Zuma was afforded a fair trial or not, or shouldn't with any vigor, or rather put it that way.
All right, I just want to get some clarity. His rulings, was it what he said with the rulings or the decisions that came out of his rulings that may cause the apprehension?
It's a measure of both, because the question really is this. There will be an application, as we've heard, that will be made for the recusal of Billy Downer. And at the center of that application will be the private prosecution that Mr. Zuma has brought against Billy Downer. The main theme will be that Billy Downer is so conflicted now, being an accused in the other matter, that he shouldn't play any further role in the prosecution of Mr. Zuma. Of course, that will require an assessment of the prospect of that private prosecution and the merit of that private prosecution. And Judge Piet Koen has been quite clear that he doesn't feel that Billy Downer contravened any law. He feels that the application by Mr. Zuma would have, it went to areas which operated naturally for the National Prosecuting Authority in how they would disseminate information relating to criminal matters. And certainly he didn't think that the private prosecution would have any prospect of success. So I think he has been quite clear to that. So then the question would be, would Mr. Zuma reasonably foresee that the judge would be able to disabuse himself of those previous views and possibly come to a fresh outcome if he was presented with different sets of facts? So I think that is what makes this matter particularly difficult, because in as much as we assume that judges can disabuse themselves of matters such as those, I think here it would be hard for the public to feel, and Mr. Zuma, to feel that he actually was able to do that completely, and that is where the danger lies for the ongoing integrity of this trial.
All right, so the reason I'm asking is a precedent being set here? Because future cases that might have similar sort of circumstances, a defense attorney might use this process. They know that push the judge to make certain rulings over a period of time, and then at some point you can use that to checkmate him and get him off the case.
I don't think a precedent per se is being set, or any new rule is being set. It's always open to any one of the parties to apply for the recusal of a judicial officer if they believe that the test for recusal can be met, meaning that if there is actual bias that is displayed by the judicial officer in the proceeding, or there is a reasonable apprehension of bias. What Judge Koen has done now is illustrated another instance in which judicial officers may be recused, and that is them raising the issue by themselves. So I think, there would always be that ability by any litigant to bring an application for a judge to recuse themselves at any point in the process. That right is always afforded to a litigant. I think what Judge Koen has done here is he's avoided any potential skirmish down the line, which I think, given the way the matter has dragged on over the past 2 decades, it's reasonable to assume that an application like this would come down the line. And I think he's really protected the court from, the outcry that we see when courts make decisions that litigants do not, or especially in the political space, that they do not necessarily agree with. So I think wise decision on his part and a good display of judicial leadership, more than setting a dangerous precedent, because recusals are part and parcel of the court process anyway.
Perhaps one contingency still left to deal with then is this private prosecution. And I wonder, can a private prosecution interfere with a public prosecution? In other words, can what happens in the private prosecution between Mr. Zuma and Downer affect the prosecution by Downer of Zuma?
And I think that is really the crux of the question. And I think what Judge Piet Koen has said here, because it's a very novel situation that we are witnessing, is that it certainly does ratchet up the question of a conflict of interest if you have a prosecutor on the state side being prosecuted for a potential crime relating to the prosecution of the matter. I think you can't avoid the question of whether there's a conflict of interest here. The question is, how material is that conflict of interest? And I think more importantly, how far will it go into eroding Mr. Zuma's fair trial rights? And I think that is still a question to be decided, and we are likely to see that being decided in the application that will be brought by Mr. Zuma against Billy Downer for him to be removed from the trial. I think the court will be seized with that particular question. It will be an important question because it will implement further safeguards relating to private prosecutions. I think the series of these private prosecutions, the one against Billy Downer, the one against Karen Moore, and the one against the president, will see a development and a clarification of the law relating to private prosecutions, I think with a view to ensuring that they're not actually abused in the hands of private citizens.
Yeah, I was just about to ask a little bit more on that. When the National Prosecuting Authority decides that they're not going to prosecute a case, are they compelled to issue a nolle prosequi, or are there minimum standards that need to be applied by the person applying for the private prosecution, the nolle prosequi? Otherwise, you could have people just waking up each morning and saying, I don't like Mr. Phiri, I want to do a private prosecution on him.
That's a very good point, Peter, because I think for many people that have experienced the criminal justice system in this country, they will know that it's very rare that you come across a no prosecution certificate. It's only in instances where the accused requests it himself, or for whatever reason the NDPC feels that they need to issue a no prosecution certificate. But it's very rare that you find a certificate of this sort, even when there is a declination to prosecute a particular individual. So I think that would become a very important factor in deciding the instances within which a private prosecutor will be empowered to prosecute, because it's a good question that there should be a funneling of cases that are actually worthy of private prosecution, given the immense power that the legislation puts in the hands of a private individual as against another private individual, where they could actually essentially be abused or harassed through the court process.
All right. Benedict Phiri, we'll leave it there. Thank you very much indeed for giving us some important answers which raised more questions. So we'll have to wait and see what the courts, how they make sense of all of this. Thanks so much indeed. All right, that's legal analyst Benedict Phiri talking to us about Judge Koen recusing himself from the corruption trial that involves former President Jacob Zuma. And most people saying that this was a good thing as it preserves the integrity of the case going forward, which will kick off on the 17th of April, all things being equal.